I have with me Spar and Bernstein civil rights and litigation attorney David Moreno. He is back today to discuss the newest developments in the case of George Floyd's death while in police custody. We're also going to talk about what to do if you're arrested or injured by the authorities while you are protesting, what legal recourse you may have. Now, David, you came on last Monday to discuss the George Floyd case, and a lot has transpired since. First of all former officers have now been charged. Now, let's discuss these charges. First, Derek Chauvin, the former officer who kept his knee on Floyd's neck for 8 minutes and 46 seconds, including 2 minutes and 53 seconds of which Floyd was non-responsive. He was initially charged with a third-degree murder and manslaughter. The other former cops, Tao, J. Alexander Kung, and Thomas Lane, they had not been arrested, but last Wednesday, Minnesota Attorney General Keith Ellison announced that Chauvin's charges had been upgraded to second-degree murder. And the other three former officers were charged with felony aiding and abetting. So let's talk, first of all, what is the difference between upgrading the case to second-degree murder from third-degree murder? And if you can also break down what is first-degree murder for us. And by the way, hello.
Hey,
by the way, hello.
How you doing, Brad? Always a pleasure to see you. Nowadays, it's the only way I can see you. But there are a number of differences between third-degree murder, second-degree murder, and first-degree murder. The biggest difference is going to be the exposure of incarceration time. While they vary in different states, obviously first-degree murder in Minnesota, just like in New York, that carries a possible sentence of up to life in jail. Whereas second-degree murder can carry a sentence of up to 40 years in Minnesota, and third-degree murder can carry a sentence of up to 25 years. When we're looking at first-degree murders under the law in Minnesota, we're looking at
the difference is 30 years of life between second and first.
Up to 40 of years in jail and life. 40 years.
Now, if he's sentenced to 40 years and it's just second degree, he's 40 something. He would get out when he's 80 something, or he would get out before.
He would probably be eligible for parole prior to that. If he's a model prisoner, right, he'll get out. He can start seeing the parole board about 85% of the way through his sentence.
Do you think they'll get to first degree murder? You're a former DA.
Yeah,
you're a former DA. You used to do this.
Yeah, I did. I didn't used to do this, but
you didn't do the biggest civil rights violation in American history, which this is turning out to be.
I would hope not. We wouldn't be sitting here if I was that kind of person. Right?
But you used to prosecute people all the time and decide
what's appropriate to charge. I think.
You think
it's going to be difficult to get the first degree murder charge for a number of reasons. In the state of Minnesota, the main, you asked the question earlier, what's the difference between first degree and second degree? The main difference in first and second degree in Minnesota in terms of murder is going to be premeditation. It's an unlawful killing that's both willful and premeditated. Second degree murder is not premeditated, but it's intentional, right? And that's going to be the main.
The difference between premeditated and intentional would be what in the law?
Under the law, premeditation doesn't necessarily contemplate, the way most lay people would think about it, that I'm this angry person in my house writing down a kill list and I'm writing down all of the different ways that I'm going to kill them. Under the law, something can be determined to be premeditated. Intent can be determined right at the scene of the crime. Premeditated would require some level of intent to go out and kill that person that day.
So to get first degree murder, you would have to show that this cop on his way over, or when he saw George Floyd, before he even touched George Floyd, that's George Floyd, I'm going to kill him.
Yes. To make it simple.
It wouldn't have to be, what if he's on his neck and he hears him choking and he says, you know what, I'm going to put a little more pressure on, I'm going to kill him.
Yeah, that's a change. That's a change in intent. That would be probably a little bit in the gray area under the law, but I would argue that it's probably not premeditated. That's one of the main reasons why why the family's attorneys in this case, Ben Crump and Lee Merritt, are concerned with the pre-existing relationship that Officer Chauvin and the deceased George Floyd may have had at their former workplace where they overlapped.
Let me give you these facts. Floyd and Chauvin, you're right. They worked at the same nightclub in Minneapolis. They overlapped. Their work overlapped. We don't know whether they know each other or not. Now, Maya Santa Maria owned the El Nuevo Rodeo Club in Minneapolis on the south side, until selling it months ago, and confirmed on the news that they both work security at the establishment. Now, Chauvin was the club's off-duty officer for nearly 17 years. Floyd worked there for roughly a year in 2019. Santa Maria, he was the former owner, told ABC she does not know if two of them ever spoke, but they were in the same club working, okay? Because Chauvin worked outside, Floyd worked the inside, but they're still at the same club working. She said if the two men had crossed paths during their time at the nightclub, it would probably not have been something they remembered because there were often several dozen people working security on popular music nights. Now, Santa Maria also said Chauvin sometimes had a real short fuse. He seemed afraid when there was an altercation. He always resorted to pulling out mace and pepper spray, everybody in sight as soon as there was an altercation that was started. What does that add to your analysis?
Well, I think Miss Santa Maria, she's guessing a little bit whether or not they actually interacted, right? Brad, you and I obviously work in the same building, right? I don't know whether or not you know the security guard downstairs. I'd probably bet that you know him by his name, right? We all do. We all have different levels of relationship with it. I mean, if I'm not down there with you, I can't say whether or not you have that relationship. What is interesting, though, is the characterization that Officer Chauvin had a short fuse or a short temper, while at a job at a nightclub, right? You would assume that someone who was a training officer in the Minneapolis Police Department that had close to 2 decades on the job training would be able to handle situations at a secondary job nightclub without escalating things or showing a temper, right? Even as a layperson, most security guards, are able to manage the environment that they're working in. So I do think that that's a relevant point. And that is something that if this case were to go to trial, the prosecutor could look into bringing that in as what you call Sandoval evidence. Sandoval evidence at a trial is going to be a pretrial hearing to determine whether or not prior bad acts, not necessarily things that led to criminal convictions, but anything bad that you did, the defendant, if those things would be relevant to this case. I would argue, as the prosecutor, that his intent, his motive, and his common scheme, what he does when he's provoked or belittled, all of those things would be relevant to the state of mind that Officer Chauvin had while his knee was on the neck of George Floyd for 8 minutes and 43 seconds. I would use that argument to show that his intention there was a nefarious one based on his prior bad acts. Now, obviously, we can't use prior bad acts to prove just because you did something bad in the past doesn't mean you did something bad here. But you can use it under the law to show a common scheme or actually, what his intent may have been based on what his intent has been in the past under similar situations.
All right. So what would you bet? First degree or second degree? It's going to stand.
If I was a betting man, I'd probably say second degree here. Just watching how everything played out. Obviously a knee to a neck is a very dangerous way to subdue someone, especially for that amount of time. But if I'm looking at things objectively, obviously taking my emotion and how I feel about the situation out, I'm looking at things objectively. As a defense attorney, I would be trying to make a distinction between a knee to a neck, which could result in the death of someone, versus, maybe taking a gun and putting it in someone's head, which is, more likely to, cause someone to expire. Right. So based on that analysis, I'd probably say it's going to fall on second degree. I understand why people are calling for first degree. Obviously, folks are looking at it. You took this person's life. You should face the harshest penalty the law allows.
Now let's talk about the other cops, the 3 that were standing around. Actually, they weren't standing around. 2 were holding him down. 1 was holding down his legs. 1 was holding down his back area. Now they are being charged as aiding and abetting a second-degree murder. What is aiding and abetting a second-degree murder? What's the difference between aiding, abetting, and in terms of sentencing, and you did the murder?
Yeah. Well, in terms of sentencing, if you aid and abet, you're going to be sentenced and exposed to the same amount of time as you would if you were the principal, right? So when you aid or abet, you are the second or third person in the situation. Like, let's take this situation here. In this situation, Officer Chauvin is the principal. Lane and Tao would be the folks that they're accusing of aiding and abetting.
Lane was down and Tao was on lookout Towers lookout.
Correct. So under the law, they would be subject to the same exact exposure as the principal officer, Chauvin. So the definition of aiding and abetting legally is to intentionally aid, advise, hire, counsel, conspire, or otherwise procure the other to commit the crime. So
they're looking at the same time.
Looking at the same time, and under the law in this situation, the prosecutor is going to argue that they actually intentionally aided in the commission of the crime, right? And they all did it from different perspectives. The two officers that were holding him down, and then the third officer that stopped, the emergency personnel that came and identified herself, that could have administered some type of aid, that stopped the bystanders, that ignored the cries of the actual deceased George Floyd. So under those theories, it's going to be argued that they intentionally aided in the admission of the crime there.
Now, Friday was the former officer's first appearance in court, and the lawyers for Kung and Lane, those were the two who were holding him down, said that their clients tried to stop Chauvin from kneeling on Floyd's neck, but were ignored. Now, I didn't see any of that on any tape. I didn't see anybody try to stop anybody. But do you think this argument holds any water?
If it were true, it might. I think we've all seen the tape. I think that's the overstatement of the year, that they tried to stop Officer Chauvin. I watched the same tape that you watched, Brad, and the rest of the world. I didn't once see either one of those officers get up prior to Chauvin getting up, or try to, remove Chauvin from on top of Mr. Floyd. The only thing that the record shows, that the video shows, is that at one point Officer Lane said, "Should we turn him over?" That doesn't mean should we turn him over and should we take pressure off his neck. It just means should we turn him over? To which Officer Chauvin responded no. And at another point, the other officer, Chung, actually said, I don't think we have a pulse. Again, that's a passive statement versus an active statement, where it's something. An active statement, Brad, is stop, get off him, you're killing him, get off him. Those are active statements. A passive statement is, should we roll him over? I don't think we have a pulse. I don't think we have a pulse, actually, to me, makes it worse, right? Because you're acknowledging this man doesn't have a pulse, but you're still maintaining the same behavior that caused that to happen.
Now, the attorneys also told the judge that on the day of Floyd's killing, Kung, who was 26, he was working his third shift as a full-time officer. So his third day in the field. And Lane, who was 37, he was working his fourth day in the field. So two of these guys were on the job less than a week. Now, Chauvin, he was the 19-year vet who was designated to train these officers. Do you think the fact that they were new to the force, Chauvin had 19 years experience, he was supposed to be training them, is that going to have any bearing on Kung and Lane's case?
Their attorneys are trying to make it have a bearing, right? They're looking at it from a power dynamic argument side, right? They're essentially trying to say that these two were novice officers that were simply following orders of the commanding officer, and that they felt that there was nothing they could have done to go against that commanding officer. I don't care if you have 1 day or 1,000,000 days on the force. Guess what? You go through the same exact police academy that Officer Chauvin went through, and from the 20 some odd years, the 30 some odd years that they've been on this earth, that what they were doing was actually wrong. So besides having some type of heightened training, they also are humans that know that killing someone is inherently a wrong thing to do.
You're right. So now, what was their duty to intervene as two basically trainees? I mean, because you heard the bystanders saying, "Dude, get off him." Yep. Now the bystanders can't go and rush the cop and tackle him, but they're all yelling, "Get off him, get off him, get off him." Maybe they should have, okay? But they're yelling, "Get off him, get off him, get off him." Mm-hmm. What was the duty to intervene of these officers who were being trained? Do they have a duty to intervene? They should have.
In Minnesota, they do not. So really? Historically, they actually enacted a law back in 2016 that they would have a duty to intervene to stop another employee when they are witnessing force being inappropriately applied or being applied for longer than is necessary. However, that law is no longer in effect. That policy is no longer in effect. There are several other states that do have duty to intervene in policies. I do think what we're going to see as a result of what happened is a lot of police departments across the country would shift to that more high and
So does
transparent level of accountability.
that would help them in their criminal case if they don't have a duty to intervene, and their supervising officer is saying they're doing the right thing. Their position, not as a human being, because as a human being, the right thing is get off the guy's neck. But as in terms of job duties of a cop, if they don't have a duty to intervene and their supervisor is saying do this, they're saying we were just sheep.
Yeah. Well, so under the police manual, there is a duty, but it's not enforceable in court. So when I say it's not required under the law. So it's not something that you can be held criminally liable for not taking an action for. Now, under the police handbook, there is a duty to intervene, but the only quote unquote tribunal in that situation would be their actual job, which we know they already lost. So that's why I'm saying in Minnesota, there is actually no law on the books or in the penal code that requires a duty to intervene. But yes, I do agree with you. It would make the arguments a lot stronger if, obviously under the law, they're not required to do it. But in the police manual, it does require that they do stop and take action when they see their comrades doing things that, shouldn't be done.
Well, of course. Now, you're a former Manhattan Assistant District Attorney. Duty to intervene exists in New York City. Do you think it works well in New York City as a policy? Do you think it works well in practice?
I would love to say that it does. Unfortunately, I'm not going to disparage my old office or any of the great cops that we have in some of these cities, but, there is quote unquote mob mentality a lot of times in police departments. Even if folks would like to intervene, they have been systemically subject to harassment, bullying, and scare tactics within the department, those that go against sort of the grain or against one of their brothers or against the shield. So it does make it tremendously, that makes it tremendously difficult for them to actually go out and do that. In the Manhattan DA's office, I do know that there are specific measures set up so that police officers can do that sort of thing reporting wise and be protected from scrutiny in terms of other officers knowing. But that's what happens after the fact. If they were to take action during, the commission of this, there may be some blowback. I mean, a great example of this, Brad, is what we saw in Buffalo, right? And I don't know if we're going to get to that later, but we saw that video where the emergency response team is marching down the street like the stormtroopers. There's a 75-year-old man, and one of them shoves him down, and the rest of them keep it moving as if nothing happened, right? That officer gets put on leave, and guess what the other 57 officers do? In solidarity to the guy put on leave, they all decide to quit. I mean, if that doesn't tell you where the mindset is of the systemic mob mentality, then I don't know what does. And obviously every department is different, and big state departments and city departments are going to be different than your local villages. Maybe at some, small town on Long Island or in Westchester, when it's 20 cops, they might be able to hold each other a little bit more accountable. But when you got a police force in NYPD that's over 20,000, it's a little bit more difficult.
Yeah, we're going to get to all of that tomorrow because we're going to invite you back to talk more. But before you leave, I have one last, question because this has been on my mind. Now, there's two autopsies. Mm-hmm. Two autopsies were released on Monday, and both agreed that George Floyd's death was a homicide, but they differed over the specific cause of the death, and they also differed whether there were contributing factors beyond Chauvin kneeling on his neck. One of the autopsies said he was high on drugs, he had alcohol in his system, he had underlying health conditions. The other one didn't mention any of that. Would this have a bearing on this case, the two conflicting autopsies? And which autopsy is going to be brought into the courtroom?
Both. It's just like when we're dealing with a personal injury case and we have our expert doctor, and an insurance company has their expert doctor, and it's basically up to the advocates on both sides to show which doctor should be credited based on their training, their experience, and whether what they're saying is credible and what the evidence support, in terms of what the evidence supports. The one thing I will say is that the homicide being on the autopsy report has no bearing because that's a legal conclusion, right? That's not for the ME to determine. What they can determine, though, is whether or not, and I think the main thing that jurors are going to be highlighted or told to focus on is what the cause of death was, whether it was asphyxiation, which we know is some sort of blockage of the throat or the breathing tubes, whether that is the thing that primarily caused the death, or whether it's going to be outweighed by all of the other underlying medical problems that they're now saying that Mr. Floyd had. And, we know in the first medical report, the first autopsy, they're alleging that there was some sort of substances in the system. I can tell you, obviously from looking at someone, you can't tell whether or not they had a bill of health, but Mr. Floyd was a, former athlete, strong, big gentleman. I doubt that, there was something going on that just caused him to die there besides, a grown man, over 160 pounds applying, probably twice that amount of pressure on, someone's neck was the reason for his death. But yeah, I think it's going to be based really on, who those coroners are and how they present their actual arguments and what support they have for it. But they both absolutely will be part of the trial.
Well, I appreciate your time, David. Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.